In top news from Court Corner, well, SAT heard the appeal by Puneet Goenka on the SEBI order which bars him from any key managerial position in any listed company till the alleged fund diversion case is investigated by the market regulator. Now, Puneet Goenka's counsel pleaded for interim relief since the investigation will take long, and the counsel said that the direction is disproportionate. Now, SAT stated that it's not satisfied with the time taken by SEBI for investigation, considering it involves public interest for the Zee-Sony merger, and is going to give the final order on this matter on September 8th. Now, this is not a standalone case because SEBI has passed similar orders in case of Eros and Brightcom as well. Let's discuss this matter with Cherag Balsara. Cherag, to begin with, is this SEBI order of KMP stepping down unprecedented? Have we ever seen this before for any particular case that SEBI is investigating?
Well, actually, as you mentioned, there are other matters also where SEBI has very recently done this, but it's for the first time that SEBI is taking drastic action of asking the directors to actually step down or stay or keep their directorships in abeyance and not continue to act as directors in view of the alleged infractions committed by them. So in that sense, this is an unprecedented order in the case of Puneet Goenka passed by SEBI.
Right. And when we talk about the proportionality of the offense, is the SEBI's order in the realm of that proportionality? Because that has been questioned also by Puneet Goenka's counsel in front of SAT.
Well, when any authority passes an order, it has to keep the Wensbury principle in mind. That is, that its order has to be proportionate and commensurate with the infraction that is committed. Now, in the present case, the infraction that was committed, that is alleged to have been committed, was way back in 2019. And there are arguments on both sides. In fact, there is an argument that the entire funds had come back into the company, and therefore there was only a technical infraction, if at all. And SEBI has a counterpoint of view that even a small infraction could not have taken place, and therefore a drastic step has been taken. So there will be an issue of proportionality, but of late, SAT has been interfering oftentimes with SEBI orders, which shows that at times SEBI has been getting a little disproportionate under the current situation.
That's right. You mentioned about the outlook coming in from the orders that SAT has been passing in cases pertaining to SEBI orders. But what about the legal recourse for the corporates in these similar matters, Cherag?
Well, the Securities Appellate Tribunal is the only body under statute where an appeal can be preferred against SAT orders. Against the orders passed by SEBI. And from the orders passed by SAT, there would be an appeal to the Supreme Court of India, and that's it. Now, in the present case, SAT has not granted interim reliefs today. So if at all Mr. Goenka needs any interim relief, he would have to approach the Supreme Court. But keeping in mind that the matter has just been kept on 8th, I doubt whether any party will be going to Supreme Court, because if SAT takes up the matter on the 8th and it has continued the prevailing position for a period of just 10 to 12 days, that is the 8th of September, then I don't think any cause of action would arise for any party to go to the Supreme Court.
That's right. Any party which has a grouse against SAT order can really take it to the Supreme Court as a legal recourse.
Only the Supreme Court and nowhere else.
Thanks, Cherag, for putting perspective on this burning issue. And thanks so much for joining us on the show. And all eyes are going to be on September 8th order. Remember, it will also set precedent for many other similar cases. With that, it's a wrap on this edition of Big Deal. Thanks so much for tuning in.